Hello, Iron Sharpens Iron family. This is Trey from the Iron Sharpens Iron Council, and today I'm going to talk to you a little bit more in depth in natural law, human subject research, and how it all kind of comes together. I find that everyone is so confused. What are we doing here, and what are we doing there? Oh my God, what do we do next? Well, you got to have a foundation, friends. You got to have a foundation. So, to understand and learn government, we have to know what they're doing and why they're doing it. We have to understand what exactly the agenda is and where it comes from its source. So this is kind of a very nice overview of why it is they conduct community-based research and why they study your every move and how they apply it to legislation. So this is an important learning because of the fact that I think that many people either A, overlook this, or B, don't feel like telling others about it, or I don't know. It's interesting to me. It took me so long to understand this, how it all starts, and I'm mind blown that no one really ever teaches it. They're like, oh, here's a piece of paper, file this. Here's a code, use it. No, no, no. Let me say that again, no. If someone gives you just some random code and you have no idea where it derives from, how to apply it, then I don't understand why anyone would even want to make an attempt without understanding what we're dealing with. Sounds good if you read it, but many times you'll find people getting thrown out of the courtrooms because it's inapplicable. Well, there's a lot of reasons behind that. So I hope this brings some clarity and maybe even encourages people to dig a little deeper, study a little harder, but more effectively, in a more effective way. So let's talk about customary law. And the reason I want to talk about customary law, because it is the derivative of natural law. And typically when you are in court dealing with statutes in the non-positive law form, this is what we're looking at. Okay, so you're hearing a lot of things out there, a lot of people talking about positive law versus non-positive law, statutes at large versus just your average statute. You know, you hear common law, always use the common law, use, maritime, use this, stop, just stop, take a breath, kick back, and understand things better. And then you will make a much better decision on future dealings with any government body or contractor, or even in your own personal life. It's just the way it is. So this customary law, I'll just go ahead and read it and I'll explain as I go through. All right. So legal custom is the established pattern of behavior that can be objectively verified within a particular social setting. A claim can be carried out in defense of what has always been done and accepted by law. Related is the idea of prescription, a right enjoyed through long custom rather than positive law. So what we're saying here is that we first have to establish a pattern of behavior amongst a community. And I have talked about this in previous videos. So if you want to go back, if you haven't listened to any of the previous videos, please do so, because I explain what is called community-based participatory research. This is how we learn about the pattern behavior that a society customarily displays. We can't just know that. We have to analyze it, critique it, and figure it out and narrow it down to a fiduciary sort of, what would you say, formation or foundation. Okay, so in a legal custom that needs to be established, first one must conduct human subject research of a targeted group. So if we want to know how parents behave in our society as the norm, then we will conduct a study that will target a group of parents within each community around the United States. Once we have established the parents' customary beliefs and behaviors while parenting, we can now lay out the common law principles by which a parent should or ought to know how to behave. This is common law practice because of the fact we can now, after conducting the study, presume that every parent has a common knowledge that we don't beat our kids, or our kids then will, or the courts will then intervene because it will be construed as abuse. That's common law, friends. So if a common man cannot interpret or read law, he has to, at bare minimum, be educated on how to understand what is right from wrong in the eyes of the public, in the eyes of society. Okay? So if we have that established and know what all of those prohibitions are when it comes to parenting that would lead to harm to the child, if we already understand all of those things and the community has been educated that certain types of behaviors of the parent adversely affect the child's emotional health and well-being, then that becomes a man's common knowledge. And therefore, as long as he's been educated on the common principles of what is right and wrong during parenting, we can say now that we have a common law violation or common law right to something. So all of this is stemmed from how we can review the behavioral patterns that are customarily demonstrated by the public in which we live. So it may differ from United States, from America, down to South America and to China. All of us probably have a different sort of cultural, behavioral ideas about how to shape and mold our children and what is best for them. So what is going on here, as they are trying to unify the system or create a one world order, right? We want to make it so that it's all the same, whether you're in China, whether you're in America, or wherever you may be. We want all Chinese and all Americans to all believe that a child has the right to be psychologically protected from certain types of actions of a parent that leads to his demise, right? So we know that the cultures are so very different that, in the current day and age, that is not a possibility. So we have to figure out how to change that thinking from the nations, although they are separate, and make them feel as though the same rules apply. This is what it means to have a legal custom. So again, all of this is stemming from natural law, because we understand that man has a natural patterned behavior, and we also know what it takes to change that natural perception of man to believe something different, but we must do so through education, okay? Bottom line. So a claim can be carried out in defense of what has always been done and accepted by law. Now, how do we know what has always been done and accepted by law? In customs? Well, that's what we have judicial opinions for. So as we move along, if there is a controversy, perhaps we do not know the exact answer to certain questions or circumstances. This is where we get the judicial review from, right? So Currently, if we look at what our statutes say in regards to babies, right? So a fetus is not within the jurisdiction of the law. The law cannot determine the rights of a fetus because the fetus is not alone. It is attached to a mother who also has rights. They share in that. And this is where the controversy for abortions arises. So by custom, it has been believed in our American system that politicians really can't get involved in matters involving fetuses because it's not their place. They don't have authority or power or right to intervene in something like that because it would also therefore intervene with the mother's rights. But this also is an issue when we think of medical kidnaps. So if a statute says that the child is exposed to drugs, this would be a misnomer because a fetus is not a child and a child is not a fetus. A child is independent of its mother now and no longer relies upon her body to survive. So this is why it's a child after it's born, or why it's not a child while it's in utero. This fetus cannot be exposed or cannot be held, mom can't be held legally accountable for legal exposure to a fetus because, again, no one has jurisdiction over the fetus except mom. Okay, so this would be what we have customarily practiced throughout the history of America. And when we change that or alter the belief of the population to believe that fetuses equally have rights to a child and that fetuses should be legally protected, you know, in a way that is separate or several from the mom, then we can go ahead and add that to legislation, right? Or remove certain things from legislation. So hopefully that clarifies. I know it can sometimes be really confusing, but these are what when we talk about persons. A child is a person because it remains within a class that we have studied, analyzed, and through customary processes and procedures, we have come up with the determination or the conclusion of how a child should be protected under the law from certain abuses. And we have determined what constitutes abuse through research and analytics on how a child is affected where those abuses have occurred. So now we have ourselves a whole slew of all kinds of different laws that kind of intertwine, intermix, and intermingle with each other. Sort of like if you think about a contract, many different things happen during the course of a contract. You know, we first have to come together, have a meeting of the minds to determine what it is each of us would like to achieve when entering into a contract with each other. It may not be on paper, therefore you don't consider it a contract, right? But through expression and implication, we are leading up to a binding contract. Now, during the time where we are expressing what we would like the contract to look like, or implying what it is that we would like to get involved in or not involved in, that is not as binding as it is once it's in writing and on paper for all to be able to see. So you've materialized these thoughts, put them on a piece of paper, and now we can come to a conclusion as to what that piece of paper entails. When it's only in its thought process and we're only having meetings and we're only discussing what each other wants, it can end up becoming a binding agreement if the facts can be established. However, it can also fall apart and be construed not a binding agreement if we don't really have any reasonable or logical way to show that one person or the other had made these agreements. I mean, it's very wishy-washy and very detailed. I'm not going to get into that, but this is just to give you an idea of what it means to practice when it comes to customs, and when we are looking at something that's really just an idea more than it is materialized fact that you can touch, taste, and see. Okay, so hopefully that's not too confusing, but I'm doing my best to break it down in a way that isn't confusing in legal definitions and terms, so that just your average Joe can listen in and be like, oh, that makes sense. So hopefully this is helpful for you guys, but we'll carry on here so that I'm gonna give you the overview of it now. Okay, so a claim can be carried out in defense of what has always been done and accepted by law. So when we say that a law is established, what we're really saying is an idea or the principle of one's actions or a legal definition has been established, and therefore, because it's been established in law, all people that get involved in a particular controversy should know or ought to know what the law is. So if we have a determination from a court that says a child is not the same thing as a fetus, and that CPS doesn't have jurisdiction over a fetus, and that their policy does not articulate their jurisdiction over a fetus, then we can say that because that has already been determined or opinioned in the courts, that it is well-established law, and therefore the actors who took jurisdiction over the fetus now no longer have indemnity or immunity, because the law has clearly been established, and if they didn't know by their profession, they should have known. Now they've broken this particular law that we are typically using in all of our courtrooms. So, you know, you get a lot of arguments. Don't listen to that stuff. Don't read it. Don't know it. Don't learn it. Just use the common law. This is the common law. So this is what most people seem to miss or overlook, or I don't even know. But if the law is well established, you know, when we're speaking about professionals who should know something, this is absolutely what they should know. However, I might be in the state of Illinois, and that legal determination may have been opinionated in a Supreme Court ruling, but it may not have occurred in Tennessee, right? So if in Tennessee, no one's ever brought this question to the Supreme Court of Tennessee, then the actors who took jurisdiction over the fetus might be able to persuade a court to believe that they did not have knowledge of the difference between the two classes. They might be able to persuade the court. They cannot establish that they didn't know for a fact, but they can persuade the court that it is logical to believe or reasonable to believe that because no one was ever taught this particular issue, that the actor could not reasonably have known that they didn't have jurisdiction over a fetus. Because they're not legal experts, they may not have realized that a child and a fetus have a different definition. So I hope that really brings clarity to some of the confusion amongst all the different things you hear every day. You get bits and pieces, but you got to bring the pieces together. So related is the idea of prescription, a right enjoyed through long custom rather than positive law. And this is in part, not completely in its entirety, but this is in part referring to what we know as the 14th Amendment. So we know that there are certain benefits we enjoy when exercising our right to a certain thing. So as our children are both a property and liberty interest, we enjoy the liberty of exercising our power of authority over our children to mold them and to do what we think is necessary to raise them correctly. Okay, so this is the custom that was practiced or hoped to be practiced over a certain period of time, right? And that's how we end up with prescription. So anyways, customary law exists where one, a certain legal practice is observed, and two, the relevant actors considered it to be law. That brings me back. The relevant actors considered it to be law. So that means all of you. If you're a parent and you once, believed in spanking your children, but someone told you if you spank your child, it's against the law, and you just believed that, and everyone around you believed that, then that means all relevant actors considered it to be law, and therefore it becomes law, non-positive law, meaning it's not going to be, you can't conclude that, but you can persuade someone to believe that they broke the law. Well, we have all these advertisements, not to spank your kid. Everyone around you believes the fact that spanking your kids is against the law, and therefore you are guilty, right? So most customary laws deal with the standards of community that have been long established in a given locale. However, the term can also apply to areas of international law, where certain standards have been nearly universal in their acceptance as correct bases of action. For example, laws against piracy or slavery. In many, though not all instances, customary laws will have supportive court rulings and case law that has evolved over time to give additional weight to the rule as law, and also to demonstrate the trajectory of evolution, if any, in the interpretation of such law by relevant courts. So when we talk about trajectory of evolution, this is how government moves in comity with the people, okay? So at one point in given time, we may have followed biblical principles to customarily practice law in the sense that, those were the moral guidelines and structures that we followed. Everybody did as a society. And there was no need for anything else, perhaps. We just followed those rules inside that Bible. But over time, things change. So during biblical times, there were no cars, for example. So we didn't really have any traffic laws, obviously. But because of evolution, we have now had to come up with a way to create an environment that is safe while one is driving a car. Now, this is why the law is kind of like a living, breathing element in our lives, because through evolution, we will need to create new laws or change old ones, repeal them, amend them, whatever it is that we need to do to kind of get with the times. So when you hear people talking about use the Bible, it's the law, that could be true if you have shown outwardly that you customarily practice law or conduct your business within the confines of what's written in the Bible. That would be difficult to demonstrate because most people are not doing that customarily. So maybe a year ago, you had no idea what the Bible said. You opened it up, you learned some things, and now you feel like this is for me. I want to practice my life, my occupation of life this particular way. Too late, because you've already demonstrated in public that you weren't following those principles from day one. Right? So now it appears to the eyes of the public that this is not your customary behavioral pattern to follow these biblical principles. And in the past, you have admitted guilt or signed a plea deal showing that you were actually in compliance with and submitted to statutory law. And because you've shown that in the past, on the record, why should we believe you now that you have some sort of biblical principle and moral? So this is, just a general overview. So don't get all huffy puffy about what I'm saying. I'm just giving you an example. There's a ton more to that. And, I'm not trying to get religious, just trying to give you an example of something that everyone can kind of relate to and understand. So in many, though not all instances, customary laws will have supportive court rulings and case law. And that's what I was talking about, where we have a controversy that arises because the population is divided in their belief or their customary practice. This is why we get court rulings and case law out of this. So if half the population believes spanking your children is abusive, and the other half of the population believes it is not, now we have a controversy that we can bring into the Superior Court so that we can allow the legal experts to determine if spanking a child in fact is a crime, or if in fact somehow is criminal in the eyes of the public, right? So how do we decide that? When the community is divided with different cultural and religious beliefs, how can we really determine if that's the case? Well, what we would have to do is we would look to our experts to decide. Well, not to decide, but to persuade the court on one side or the other. So then we'll look at experts and what do they say about spanking. So the majority of the experts come up with a conclusion based on studies that they've done over a decade that children who were spanked have become somehow emotionally disturbed in the future. So that's how the court will kind of weigh in on one side or other when the community is divided in their beliefs. So if the expert says it causes harm to the child, then the court has to exercise its jurisdiction and its power and authority to protect the child. So that split between the community becomes fairly irrelevant because the focus becomes on what do we need to protect this child or don't we? Do we need to take jurisdiction over this child or don't we in these types of circumstances? Well, the experts say yes, because we can show through our course of study that it does in fact harm the child, and this is how. And then they'll show all of their scientific conclusions about adults that they studied who were spanked, and they can show that it somehow adversely affected their life, therefore it caused harm, okay? So I hope that, like I said, I know this is confusing, but stay with me, bear with me. I hope it clarifies things. All right, so let's see. Standards of community, right? Most customary laws deal with standards of community. Again, how do we determine what the standards of the community are? There is no way to just know this. And this is why I guide you guys to look into community-based participatory research programs, community-based interventions, and services. Okay, these are how we develop the expert's opinion to sway or persuade the law to determine when a law is being broken. Okay, so the standards of the community is basically how they conduct their research, and then they analyze that research to see what effects or outcomes of a certain action occurs over a period of time. And that's how we move legislation, because once the experts have weighed in on whether or not something is harmful to a member of society, then they will also lobby legislation. They will begin to tell the legislators, okay, we found that this is bad for the child. We have got to get you guys to move on this. We need to get you to legislate to protect the child in this kind of way. This is what these experts are doing, and this is not what the people are doing. So while they're out there lobbying for these standards to be set, do these standards really represent a genuine culture of the people? Or are they pushing it in the favor of the experts more so than what the people actually believe? This is important stuff. So, nature definition and sources. A central issue regarding the recognition of custom is determining the appropriate methodology to know what practices and norms actually constitutes customary law. It is not immediately clear that classic Western theories of jurisprudence can be reconciled in any useful way with conceptual analysis of customary law, and thus some scholars like John Kamroff and Simon Roberts have characterized customary law norms in their own terms. Yet there clearly remains some disagreement, which is seen in John Hund's critique of Kamroff and Roberts' theory and preference for the contributions of H.L.A. Hart. Hund argues that Hart's The Concept of Law solves the conceptual problem with which scholars who have attempted to articulate how customary law principles may be identified, defined, and how they operate in regulating social behavior and resolving disputes. Regulation of social behavior in every case, in every court. And let me show you why. So when we are regulating one's behavior, we must first identify the class of persons, as we talked before. So parents have a certain behavioral pattern. They exercise their power and authority over their children in the rearing of their children, okay? So this is what it means to regulate a social behavior. So once we've determined how that parent is behaving, we then have to determine which of those behaviors is incorrect and causes harm to the child. Now, because we understand that some of these concepts or allegations may lead to criminal charges, we also have to realize that criminally charging a parent who's abused their child that wasn't brutal or cruel, but maybe just on the neglectful or antisocial side of things, we also understand that by criminalizing that parent, we harm the child, because now the parent will go to jail and the child will be left without ever knowing what their parents were like, and this can also impose a harm upon the child. So we cannot criminally charge these parents and lock them up. This would be wrong because two reasons. Number one, although the court presumes they know all of the common factors that lead to harming a child, they also have to leave room for error. So we could presume that the parent was not ever in a deliberate or malicious way trying to harm their child, but they just didn't know how to properly raise a child. Perhaps they have disabilities themselves that lead to bad behavioral patterns and indirectly hurt the child. So this is why we have general provisional courts. So in understanding that part of things, we have to look at, so I'm using the Juvenile Act as an example, the Juvenile Court Act as an example, just so you can understand that when you're looking at statutes, they will tell you where these statutes come from, their intent, and all this different information, and you kind of want to know what you're dealing with. So this is the act that shall be known as the Juvenile Court Act of 1987, and as you can see at the heading, the very top, what does that say? General provisions. So I'm not going to get into the whole statutory nonsense right now because it would take forever, but this is just to show you that we are looking at customary practice, common law, that leads to a general provisional court, and that general provisional court doesn't operate in positive law or conclusionary law and fact. It operates more on custom, the customary belief of the people, or politics, okay? It operates more in the level of contract, fiduciary duty, trust, so forth and so on. So we're presuming a parent already knows everything inclusive of what causes harm to a child, and that they therefore, in their fiduciary duty of care, will refrain from doing anything that breaches that trust and leads to some sort of harm towards the child. Okay, so this is basically just an overview of how the courts weigh in on this. So the purpose of this act is to secure for each minor subject hereto such care and guidance, preferably in his or her own home, as will serve the safety and moral, emotional, mental, and physical welfare of the minor and the best interest of the community. So this isn't always about the child, okay? And that I can get into deeper as well at another show, but it is not simply about whether or not the child is being harmed. It's about the trickle down or domino effect once a child has been severely emotionally disturbed that will lead him to be a less productive member of society. So it hurts the community. So your bad parenting that leads a child to a mental incapacity could possibly harm the public based on that idea, right? And this is, again, natural law, right? So without reading all of it, there were some other parts in here too that I wanted to go over. So bear with me a second here. I'm trying to find it. Okay, so in those extreme cases in which the parent's incapacity to care for the child, combined with an extremely poor prognosis for treatment or rehabilitation, justifies expedited termination of parental rights. So if an extreme case occurs, right, what they're doing here, instead of criminally charging a parent in a criminal court that leads to punishment, they are correcting the parent's behavior and protecting the child simply by terminating the right of the parent to exercise his power and authority over the child. Okay, so why do we refrain from charges against someone if we're talking major cruelty, extreme circumstances where somebody's really harming a child, let's say assault and battery? Why would we refrain from charging that person with assault and battery? Wouldn't this be better to the community? Because if a parent exercises that kind of abusive power over their child in such a harsh way, in such a heinous way, we could pretty much rely on the fact that that human being is going to do it again to another human being, whether it's a child, a woman, or someone else. So in my opinion, and this is just my opinion, I don't know much, but in my opinion, this is where these particular general provisions fail the communities. Because if someone, and I can tell you this, about 1%, 2% at the most across the states, has a parent ever been actually convicted of some sort of cruel and unusual punishment that or abuse where it was, assault and battery in that circumstance, only like 1 or 2% of the parents who get investigated in these matters actually end up having that kind of accusation or allegation against them. But very few of them actually end up in a criminal court and do jail time because of this. So I am really confused as to why they pretend this protects the community, because, like I said, just terminating a parent's right when they've expressed such cruelty towards the child would tell me that they don't have empathy or sympathy. So just removing the rights from their children doesn't really cause for them to feel that they were punished in any way. Whatever. I would think they'd be like, whatever, who cares? I mean, obviously they didn't care about the kid if they were doing all these things. So how does this prevent them from doing future harm to the community? It just doesn't make sense to me personally, but there's something to analyze in your own minds to think that over. If someone hurts a child, okay, we don't need to implement child's rights. All humans have rights. Children are human. Constitutional rights are protected for men. Children are sons of Adam, sons of God. Therefore, they are classified as being the species of man. So all those rights exist before we put in this nonsense. So that's just my little personal rant on it. But something to really think about when we're looking at all of these general provisions, because it sounds good on its face, but in the end, I'd say no. All right, so this really, I'm not going to get, like I said, too detailed into this act, but I just wanted you guys to see some of this stuff within this act that makes sense to all cases, because this is a great way to see how agency works, guardians work, power of attorney works, okay? So agency means a public or private child care facility legally authorized or licensed by the state for placement or institutional care, or for both placement and institutional care. So child care facilities, okay, can mean many different things, you know, and I'm not going to get into that too detailed either, but understand that when they're talking about agency, it typically is a facility of sorts that's licensed by the state. And so whatever you're dealing in, whether it's child or traffic, you know, we got to think about which facilities represent the agency. Okay, and institutional care for both placement and institutional care. So institutional care, if you're dealing with other things, could mean correctional facilities such as local county jails. Correctional facilities, they are not for punishment, okay? They're to correct your behavior. So if we think about prisons, that's different, that's punishment. And that's what these general provisional courts kind of refrain from punishment and provide more corrections. Association means any organization, public or private, engaged in welfare functions, which include services to or on behalf of children, but does not include agency here and defined. So an association, you know, we think about familial association, if you are, say, a homemaker. This might make you an association or in association with a child because you do engage in welfare functions. You service your child on many different platforms. You're a social worker, psychiatrist, doctor. You are a judge, a lawyer. You are a farmer, a cook, a maid. So many things that come with that. So these are the associations that a parent may have with their child. Okay, so whenever a best interest determination is required, the following factors shall be considered in the context of the child's age and developmental needs. This is what they're saying. Every single fiduciary person within the child's life needs to follow this kind of format before they intervene into a family's power and authority. Before they abridge any of those rights, they have to make sure that they're operating in the best interest of the child. If they're not operating in the best interest of the child, then they are with operating outside the scope of their authority, which, again, we're not going to get too much into that, but just to let you know, there are guidelines pretty much for everybody. So court means the circuit court in a session or division assigned to hear proceedings under this act. Dispositional hearing means a hearing to determine whether a minor should be adjudged to be a ward of the court, and to determine what order of disposition should be made in respect to a minor judged to be a ward of the court. So this is them to determine if they even need to make a determination that the child is neglected, dependent, or abused. Because if they don't determine that the child was dependent, neglected, or abused, there's no reason to proceed. Again, this is, you know, child's court or juvenile court, but it's applicable to everything. Guardianship of the person, that's really what I wanted to look at the most, though. Guardianship of the person of a minor means the duty and authority to act in the best interest of the minor, subject to residual parental rights and responsibilities to make important decisions in matters having a permanent effect on the life and development of the minor, and to be concerned with his or her general welfare. It includes, but is not necessarily limited to, the authority to consent to marriage, to enlistment in the armed forces of the United States, or to a major medical, psychiatric, or surgical treatment, to represent the minor in legal actions, and to make other decisions of substantial legal significance concerning the minor. B, the authority and duty of reasonable visitation, except to the extent that these have been limited in the best interest of the minor by court order. The rights and responsibilities of legal custody, except where legal custody has been vested in another person or agency. And the power to consent to the adoption of the minor, but only if expressly conferred on the guardian in accordance with Section 2-29, right? So guardianship of the person has several seats. You can have guardianship and be the parent. You can have guardianship and not be the parent. But when this dual relationship exists, it doesn't alleviate or eliminate the rights of any of the parties. So just because I'm a mom who, say, has a guardian ad litem on the case, just because the guardian was appointed, it doesn't mean that I have been, any of my rights to determine the welfare of my child have been diminished. I still get to make those determinations. Okay, so once the guardian has fully taken over, because perhaps I had certain rights terminated by court order, that guardian now has authority behind the scenes that they don't have to inform you. They can authorize medical treatment. They can authorize medical research. They can authorize psychiatric research of your child and anything else under the sun that they want, basically. So I just kind of wanted to give you an insider view of what it means when you're in the courtroom to have something like a guardian. Because when we look at our appointed attorneys, they're a legal guardian because, in a sense, I mean, because if you think about it, you're giving them the power to determine your legal rights and responsibilities. So would you be in legal custody of an appointed attorney, or even one purchased, in private, whatever? Yeah, I'll let you think about that, but I think it's something to think about. Because your power that you're conveying over to an attorney means a lot of different things, that you no longer have the right to speak up for yourself. You gave that up to him when you conveyed your rights to him. So all these things kind of come into play. I just wanted to give you a general idea, though, of how these natural law concepts are applicable to everything that we do. So keep in mind, as we were talking about before, is that the customs of the people is what we are dealing with when we're in these courtrooms, in this matter, specifically the juvenile court. But you go and look at your traffic courts and you're going to see that same heading, general provisional court, meaning that they are operating on the side of social behavior, not the law that we think is written to stop, prevent crimes. And inside of these general provisions, they define things as being criminal acts that are not actually listed as a criminal act under the criminal code. So that's another thing to kind of keep in mind when you're dealing in this scenario here. And this is just, like I said, a nice general overview and to give you some insight as to how this nonsense works. And I hope it does help you to learn government, because when we learn government and we learn the game, we level the playing field. So let's keep on trying to level the playing field by you guys just watching, using your own critical thinking, and using your own deductive reasoning to determine how this is working versus how it should be working. I don't make this stuff, right? I'm not writing it, so don't shoot the messenger. I'm not in agreement with it either, but this is what I want you to keep in mind, because a lot of times people will tell you what they want the system to be. So they'll tell you to act in a way based on their desires, their wishes of what we were working with. But unfortunately, it doesn't really work all that way. So do I want it to be that simple? Absolutely. but it's not. So learn it, learn it, learn it, learn it. And we'll see you in the next show. I'll continue to bring forth some of these truths, and hopefully they're valuable to you and helping you to grow. Click on the subscribe button below if you like this message and you haven't done so already. Make sure to click the bell so that you can get notices when I put up new videos. And make sure that if you have any comments, questions, or whatever, just put it down in the box below, and we'll try to answer questions. And sometimes I'll even do videos to answer your questions if it's easier. But everybody have a great day, and learn, learn, learn.